Hello, everyone. I'm Richard Fink, a lawyer who specializes in workers' compensation law in Ontario. The Injured Workers Legal Side podcast with Richard and Paul is our podcast today. And Paul?
Hello, everyone. My name is Paul Taylor, as hopefully everybody recalls because you've been watching our fantastic podcast. I'm a paralegal who spends a great deal of time helping injured workers deal with the Workplace Safety Insurance Board, just like Richard, and also the Workplace Safety Insurance Tribunal. I also specialize in human rights matters and charter rights matters. If you want to reach either one of us or be part of our podcast as a guest speaker, like last week, Mr. Greisick was from Winnipeg, you can contact us through the links below to our website. This week's topic is the WSIB's looming strike. Let me explain what I mean by this. Basically, the workers at the WSIB are unionized, and I believe it's Cup W. No, it's CUPE. And this union has been fighting with the WSIB. Basically, one of the issues is you have surpluses and yet you're not giving any increases. The basic issues or concerns were they're giving rebates to employers. They have massive workloads, which is causing considerable stress leave for the workers there. Another concern that's underlying and I think is coming up is the use of artificial intelligence in making decisions at the WSIB and a greater concern making medical decisions. What do you think about that, Richard?
Well, we have trouble getting decisions from case managers just in terms of time. It sometimes takes months to get a decision on whether the worker still has a disability, which is very difficult for the injured worker themselves. And we get decisions that are nonsensical, where the decision says there's nothing wrong with you, but you still have restrictions because the case manager hasn't read the read the letter properly to make sure they're being consistent. So you can see they're overworked.
Yeah,
And
you can sympathize with that fact, and this is where injured workers diverge and say, they take it very personally when I try and tell my clients don't, because a lot of the times there's pressure from up top. And I think we're starting to see this pressure from up top when they're denying everything. And you're like, why would you deny this? I have MRI reports, specialist reports, doctor reports, or the guy is still in the emergency room at the hospital and you're saying he can work. It defies common logic, right?
well, Malcolm Gladwell, who's a noted author, has said it takes 5 years to be competent in your trade and 10 years to reach your maximum competency. And too many of the case managers are under 5 years. And they used to have a very senior staff there who would monitor and assist the junior people. And they retired them all a few years ago. So the WSIB is also missing a strata of their historic staff, which had the experience to make certain that the act is being properly applied.
Yeah, this is something I've noticed in other administrative boards and tribunals. It's a nightmare at the landlord tenant board where I read one article by Tribunal Watch Ontario. They said they have twice as many staff but are taking twice as long to make the decision. So you'd say, well, how is that possible? And you hit it right on the head is a lack of experience. Because to my understanding, from through Doug Ford's orders, he refused to keep on experienced decision makers because he wanted to do his platform. I mean, getting away from that subject, it's the more important thing is the delays in the justice where tenants' hearings are 2 years, landlords have reduced down to 4 months. Then moving on to the Human Rights Tribunal of Ontario, I believe, and I could be wrong, the hearing time frame, if you file an application now, is about 10 years. That's scary. And I've dealt with some of the decision makers. You can tell the same feeling is right across. And I think and correct me if I'm wrong, Richard, was in about 2017, 2018 was the baby boomers, the people that big cohort of society in Canada were all retiring, which left this big void of in the labor force. And in 2018, just right when they needed to replace all these workers, Doug Ford got elected and he imposed a hiring freeze, which created chaos. Now, I don't believe it impacted the WSIB and the Workplace Safety Insurance Appeals Tribunal as much, but I tend to think that they would follow similar policies, creating further delay. Like if you analyze it through, but I mean, so there's just it's an ongoing problem where I agree 100%. You can't replace experience, and management always looks and says, "Well, I can get two workers for the price of one." But then it's going to take four times the work to cover that experience of that, experienced worker.
Well, the case I did yesterday at the appeals tribunal, the date of injury was 2018. And the case, it was being heard on whether the worker still had a significant disability that would interfere with his being able to work. So it's 7 years to get to the tribunal, and the tribunal's still another 2, 3 months away from issuing a decision. So to go 7 years to have your case pounding around the WSIB and then the tribunal is rather startling.
And Ontario, this is one thing I don't know if you know, Richard, is in Alberta, if you're and it's not a perfect system, it's just I think it's a good idea while you're waiting for the appeal process. Because there's two ways to deal with the thing is that they don't talk about the hardship to the worker, meaning what happens to them while they have to wait 7 years if the board's saying you're not getting any benefits, and it turns out they were wrong, they just pay your benefits and some interest, and all is right with the world. It isn't. There was significant harm done to that person because they lost that 7 years of income. And there are ways of preventing that harm by giving what they call is interim benefits, and Alberta does it. But there's flaws in the system now because it's conservative. But when you look at the system, it's a good idea because the first thing the government says, the WSIB Ministry of Labor says when the worker's waiting so long for an appeal is, well, go on Ontario taxpayer funded social assistance. And I'm like, why? Why should I or you, Richard, as a taxpayer, have to pay for this worker when I wasn't their employee? I didn't do anything wrong. Taxpayers shouldn't have to. Workers' comp is not funded by taxpayers, it's funded by employer premiums. And I think this concept is being lost. And that's why I think the WSIB should take responsibility for these delays and the hardships caused by them. The other problem too, from the employer's perspective, when I took a course on human rights, and I didn't realize it because I was always representing individuals, was from the employer side, the business side, the respondent, is you wait 5, 10 years to go to a hearing or an appeal, and all of a sudden the witnesses they have are either dead or moved on. They've lost their response to the appeal. They may have been able to win that appeal and now they can't. So it really goes to that saying, justice delayed is justice denied, right?
Turning to AI for a second, which is one of the issues that the board staff and the union is concerned about, insofar as I assume they're worried that on the one hand, there's not enough staff, but on the other, that what staff they have may be decimated by having AI do the decision making. If AI was to do a non-economic loss award, and all you had to do was feed in to the computer the movement restrictions in the worker's shoulder and the diagnosis, then that would probably work and would save the case manager 30 minutes in trying to do all the math and calculations.
Oh,
But
I wouldn't trust it because it's run by the WSIB, and I think my greatest fear is that they would base it just like a profitable business. Oh, we're losing money, so let's cut back on paying out and reduce these premiums. It has nothing to do with the genuineness or the level of injury of the individual, right?
Well, the non-economic, take a shoulder, which is not that subjective. There's a diagnosis, let's call it rotator cuff tear. So there's a diagnosis, and the doctors will do a measurement of movements. So you could plug all that in to AI and you get out the same result as somebody doing the math themselves. When you get over to psychological disabilities, however, the WSIB currently has a checklist of what's going on. So one of the questions is, are they spending time isolated? And that's a very subjective question, which you wouldn't want to leave to AI because there's isolated in the sense that they don't speak to anybody. There's isolated in the sense they never leave the house or they never leave the room. So isolation is a very term open to a lot of views and facts. And to let the computer try and figure out how isolated they are in order to come up with a percentage of disability, I think would be stretching AI's ability. So that's a problem.
I mean, the other concern is that you can't have a computer diagnose or make a medical determination. It's just the same problem with self-driving cars. If a car is driving itself and nobody's in the driver's seat and it goes through a red light, who does the cop give the ticket to? So if there is medical malpractice in this particular case, who do you sue? Who do you go after? Those are the questions that are not going to be answered in my concern, and it's just going to be ramrodded through because the only reason why it will is for the benefit of cost savings. That's the only thing that the board is concerned with, is saying we want to do this and we're not concerned about individual rights or privacy or anything else, or even the medical profession. I took a course with or a webinar hosted by Christopher Bingham, I believe his name was, and he was touting it as AI for medical community was a good tool for the doctor, for the IME. So when you go to the doctor, they examine you, then they use the IME, the AI to, expedite their reporting process and make sure everything's fine. But again, the doctor is the one that's accountable, you know what I mean? And it concerns me because the board is moving away from that. I don't think they legally can. Like, have you noticed, Richard, with the NEL reports of, like, when I got mine back in 2000, I went and saw a doctor from a list of doctors. He examined me, did all the measurements, and went to the board. Now I'm noticing with a lot of my clients where the board is they're just doing it based on the medical in the file. And I'm like, it doesn't make any sense. So it seems like the board is going fast and furious for cost savings at any cost.
The thing that would most disturb me about AI is if they start to apply it to whether the modified work is appropriate. And I think it goes to really the heart of what's wrong with the WSIB. So let's say you've got a report from one of the board's hospitals that the worker has 5 restrictions. And then you have a report from a return to work specialist. Here's a description of the job the employer is offering that supposedly meets the restrictions. Let's say one of the restrictions is no repetitive lifting. And the employer says, well, you only have to lift 4 or 5 times a day, so it's not repetitive. So the AI is not looking at what else is the worker doing, how quickly they're working, how long they're standing, what type of other movements are there. The AI is just saying, well, the employer says 5 lifts per day or 5 lifts per hour. The report from the doctor is no repetitive lifting. Five's not that repetitive. So the job's good to go. Whereas what should be happening is, and it doesn't really happen now, is the return to work specialist should be sitting with the worker throughout the course of the day and seeing how things go, whether things could be made better, whether, although the doctor says 5 after 4, you can see in the worker's face that he's suffering, and to try and help the worker integrate and get up to his maximum potential, notwithstanding, for instance, he has a very bad back. AI will take this way of the board trying to do everything quickly and trying to process things as opposed to trying to help the injured worker. It'll take it to a new and more worse level.
Yeah, the other concern that I have with the return to work as well is, like you said, is oftentimes I've noticed where the board isn't even meeting with the worker, like you say, or even a representative like me. Now, I read somewhere in some legal papers that there's debate on the subject because it would go into that realm of procedural fairness, right to be heard. And they said, well, the problem is the WSIB is in a bit of a position because they can't compel the employer to allow you on their premises. To which my response is, yeah, I don't care. Then the return to work process then would be null and void because if the employer doesn't want to cooperate and allow the rep there, then it shouldn't happen. But like we're getting a bit off, which I tend to do all the time. But the issue with the strike, the other issue I noticed with the strike too was leading up to it was I saw a post by Michelle Zare, who's also a very big paralegal with workers' comp for injured workers, and I'm not sure about employers. I think she mainly does injured workers. And she was complaining that she was on that phone for over an hour and 45 minutes just to talk to the intake person at WSIB. So this is creating another huge problem for representatives, union reps, OWA, that there's delays in the administrative process because you can't sit on a phone for 2 or 3 hours waiting while you've got other work to do.
Well, my Pamela Hughes, my legal assistant, um, told me today that yesterday she was on the phone for 3 hours waiting to be heard. And it's like, forget it. I'm not calling them. Maybe when the strike is over, I'll start to call again, but I'm not going to call them now.
No, I'm good for you, Pam, because I'll tell you, unfortunately, at WSIB, I have an appeal to schedule with the WSIB appeals. And now my feeling is there's no point in me calling them back because I can't get a hold of them. And then secondly, I'm going to have to tell the injured worker, look, I'm sorry, you're not getting your appeal right away. They were talking June and now they're delusional. The board, I mean, because now they're heading to a strike and I'm pretty sure the strike is happening, which means, and I think I'm getting the feeling that the board in the way it does business for the last few years is they are very unforgiving, meaning they will not concede to anything of labor at all. And labor is like hanging on by their fingernails and they're not going to concede. My point about that is that unfortunately, I sense that this is going to be somewhat of a long strike. What do you think, Richard?
Well, we've got a possible postal strike on Friday. Oh, it's a perfect combine.
Yeah.
Nothing gets out of the board because they still haven't adopted much of the internet. We're still getting faxes
Really?
and letters from the WSIB. They almost never send us a real email.
I know. I
So,
got a I got a letter the other day and I'm like, why are you like it's not that I'm annoyed by it. I'm just thinking somewhat of an environmentalist, which I'm not really, but I'm like, what a waste of paper. Waste of
clients get almost all letters. They don't get emails from the board. They get letters. So once in a while, they'll get the letter. We got nothing. And they'll text us by photographing the letter and send us a text of what the letter is. So, uh,
Yeah, in Manitoba, did you know that Manitoba and Alberta, I'm not sure 100% about Saskatchewan, the injured workers can email their case manager, and so can the reps. Yet Ontario will not go to email. Now, I could be wrong because I don't represent employers. It just happens to be I haven't represented any. Um, that if the board deals with the case manager deals differently with the employers. I'm not saying that they do. I'm saying I don't know. What's
We
your
send
perspective?
our letters by email in the sense that we don't put them in the mail. But uh, this ability to email back and forth, the WSIB's been very slow to adopt it. And they've revamped their computer systems multiple times, and they've had copious problems with it over the last 20 years trying to get it down right. But the fact I still see letters in our mailbox when I drop into my office once a week is really bizarre.
Yeah, I get them too. Like my person will call me and say, "Yeah, Paul, you got mail from WSIB," and I'm like, and once in a while I'll get some from the WSIB, not too often. They're pretty good. They've seemed to have adopted the electronic communication system pretty well. But as an injured worker too, I have access to the portal and I can send messages to the board through their portal system. But I've noticed even that online portal system, which could be a great process, has been very limited. I also heard, though, with the board is that they were talking about somehow giving reps more access to the system. I don't remember exactly what it was. Have you heard anything
Pam
about
went to a seminar on that and found
uh
that it was completely useless what they're doing. At
oh,
any
that's what I
rate,
figured.
we're at the end of our time. Hopefully next week we'll get back to our topic of age 65 discontinuance of LOE, and I look forward to that.
Well, most of us won't know what it's like to be age 65 yet because we're all pretty very young, right,
Well,
Rich?
speak for yourself.
Yeah.
All right. Take care. Thanks,
Take care.
everybody.
Bye, everyone.